good afternoon, everybody. If you can please take your seat. At this point, as you know, we'll have a round, so please just make sure that you have your phones on silent so we can proceed with the round in a minute. But before we go on to the round, I just want to talk a little bit about what we're going to be doing today. So my name is Alan Feynman. I am the Chief Justice of our Mutual Board and of the Charleston School of Mutual Board. And I would like to give you some background about the Mutual Board and this internal competition before we begin. Now, our program sends students to compete in various competitions across the country in a appellate level setting. And they compete against other law schools. And our program is very small, but last year our board had an amazing success. We actually ended up finishing as a top 25 program, advocacy program in the country. And that's competing with all law schools across the country. Now, in order to be a member of our board, every year, second year law students compete among themselves in the internal mutual competition. And this year, over 50 students competed, which amounts to one of the biggest competitions we ever had. And at this point, I would like to thank a number of people who made this competition happen and make sure it runs smoothly. And without them, we would not be able to conduct practice rounds, bailiff, judge, and recruit judges for over 70 rounds we had this year. So first of all, special thank you to Lindsay Luthringer, the chair of the internal competition, who spent countless hours making the schedule and dealing with all the logistics of the competition and dealing with adversity due to Hurricane Irma. Lindsay did all that. It was funny because she did all that with joy, and if you ask her, she's probably pretty sad this is all over. Also, a big thank you to Professor Todd Bruno, our faculty advisor, who always puts his heart and soul into any of our board activities. And lastly, I want to thank the rest of our Newport board who made this happen, who held bailiff, judge, and recruit judges this past month. And please give them a round of applause to everybody. At this point, I would like to announce the 21 students who excelled at the competition and were selected to join our board. Starting with Alexis Mock, Allison Stutter, Arielle Larsen, Brittany Bianco, Brittany Point, Claudia Pichota, Devin Hludzik, English Mall, Jeffrey Domanico, George Sally, Katie Bronson, Lauren Carroll, Mallory Sikora, Mary Catherine Harbin, Michael Clements, Michael Monastra, Rachel Edgerton, Tom Guthrie, Victoria Hurse, Zach Horwath, and Zach Storr. Please give them a round of applause. At this time, I would like to introduce Judge Carmen Mullen, one of the panelists today, to give some remarks. Judge Mullen received her undergraduate degree from Indiana University, her master's degree from Clemson University, and her Juris Doctorate degree from the University of South Carolina. Following law school, she was a law clerk to the Honorable Casey Manning, served as a public defender, worked as a head counsel for the House of Representatives Labor, Commerce, and Industry Committee, before going into private practice, where she practiced civil and criminal litigation both in Charleston and in Hilton Head from 1998 until her election to the 14th Judicial Circuit in February of 2006. Judge Mullen is married to an attorney, George Mullen, and they have 4 children. And without further ado, Judge Mullen.
Good evening. And I want to thank you all for inviting me back to the Final Four Newport competition. It's my pleasure to come as a second year, and I was invited by Kristi Harrington as well as the school. So thank you for having me again. And also for asking me to make just a few short remarks before we begin. In considering what I want to say to you all today, I thought about my given topic, which is trial advocacy, and particularly appellate advocacy, and what might be important to law students about that topic. And I'm going to go ahead and tell you that it doesn't escape me that I'm a circuit court judge, so I'm a trial judge. I am not an appellate court judge. But I do believe that to be an effective appellate court judge, you have to have tried cases as a trial judge or as a trial lawyer, and I think that's imperative to being successful. So with that said, I think I have a little bit of knowledge to impart here. I also thought about what is probably foremost on you all's minds at this point as law students. I can tell you for me, after having gone to undergraduate, graduate school, and then law school, I was concerned about getting a job. I wasn't from this state, and I was hoping to be able to find somewhere that I might get lucky and someone would take me in and help me. And I will say and acknowledge this, I got very lucky. I ended up just fortuitously clerking for a wonderful judge, just kept getting wonderful jobs here, and I'm so grateful. And I've had an amazing and certainly well beyond my capabilities, a career so far that I have loved and enjoyed. And I want to wish that for you all. The one thing I do notice, and I will tell you this, and that just comes from the quality of the applications I get for my law clerks each year, is how competitive the market is. And I'll be the first to acknowledge that there are probably too many lawyers in South Carolina. And that's unfortunate, but it just makes it more difficult for you. But I do have what I think is very good news. And for me, I think it's something that if you are interested in trial advocacy or appellate advocacy, if you feel comfortable going into a courtroom and arguing and actually trying cases, there are far too few trial lawyers in this state. There are far too few people that actually go into the courtroom to present their cases and to act as mouthpieces for clients. Now, we all think we know what a trial lawyer is. I went to the dictionary to determine exactly how they define a trial lawyer, because I can tell you in all the TV advertisements and the billboards, everyone claims to be a trial lawyer. And let me tell you what the Webster Dictionary defined as a trial lawyer. A trial lawyer is defined as a person that actually and regularly tries cases. Now, the emphasis is actually and regularly try cases. Now, I've been on the circuit court bench for 11 years. I've been a lawyer for 22 years. I have tried cases in every courthouse of this state as both a lawyer and now as a judge. And what I want to tell you is this, is that I've never actually seen a TV or a billboard lawyer in court trying a case, ever. I can tell you that doesn't exist. I did see one person in Myrtle Beach one time. I won't say his name. He does exist, but he didn't actually try a case that week. But what I want to tell you is this. There is room for great trial lawyers in this state. We all know the ones that we talk about and we think about. I had the honor of being with Susan Dunn. She is one of the foremost trial attorneys in the state of South Carolina that's here today. We all know the normal names we hear about: Gedney Howe, Johnny Parker, John Nichols, people that actually go in and try cases. But there is room. And I can tell you that appellate advocacy and certainly trial advocacy is a very good career path if you have a talent in that area and an inspiration. So with that said, I want to give you just a few pointers from my perspective. I know you all have heard enough about trial advocacy. I have plenty of friends that teach the class at the Charleston School of Law. So I just want to go over a few things that I see on a frequent basis that you just need to keep in mind when you go into court. To begin with, a great trial lawyer knows how to tell a story. I've got to tell you that people overtry cases every single day. You've got to explain it. You've got to tell the story. Your jury or even your judge may not remember what the facts are. They might not even correctly remember what the facts are. But I can tell you, they will know how they felt, and they'll tell you why they decided the case in your favor or not in their favor. And that makes a difference. So just remember, it is in fact a story, and your job is to relay it. Nonverbal communication. I think it's just as important or more important than verbal communication in a courtroom. If you use your hands when you speak, do it with purpose. Don't pace. Step with authority. Make a point and move on. Pause for effect. Let it sink in. Make eye contact with your jury or judge. These are all important things, and to me they seem incredibly obvious, but I can tell you that when you get into a courtroom, people start getting the white noise that goes on in their head, and all that seems to go out the window. Remember it. Also, you need to own your courtroom. Feel comfortable in it. There is nothing more painful than watching a lawyer who is ill at ease in the courtroom. Now, I will tell you that in my family, I'm a first-generation lawyer. My family were all business people, and growing up, all my parents did was complain about lawyers. So I wasn't comfortable in the courtroom, but I can tell you the one thing that clerking for my judge did for me was that I knew that when I walked into a courtroom, it was mine, and that I owned it, and I felt comfortable. And I knew the players, I knew where to be and where to stand, and it's important. So get comfortable. As far as exhibits are concerned, that is probably the number one thing young lawyers cannot do is get an exhibit in. But even more importantly than being able to lay a foundation and get that exhibit in, which everyone seems to be so concerned about, consider your exhibits. I can tell you that any case, I don't care how big it is, it can be a construction case with 25 banker boxes, can be reduced to 10 important exhibits or less. And the reason is this: if there's more than that, you don't know your case. If it's more than that, the jury won't understand your case. And I can assure you that if those exhibits are entered into evidence, number one, either the jury is not going to look at them, or number two, after 4 days of testimony, when they receive 180 exhibits, on each exhibit, they're not going to know what was important about that one specific picture. It's a waste. So again, narrow for them. Tell the story. This seems to be so obvious, but it amazes me how times have changed. Tell the truth to your judge and your jury. I can't tell you how many times I've been lied to by lawyers. I can't tell you how many times people have misquoted the law. Don't be lazy. Pull it out. If you have to read it, fine. Give me a copy of it. But don't lie to a judge. This is a very, very small state. Judges love to talk. I can tell you right now, and I'm sure you all know this, we have a listserv where basically only the judges are allowed to go on it, and it can encompass any topic. And I can tell you that unfortunately, when lawyers do things that are absolutely outrageous, they land on that listserv. You don't want to be that person on that listserv. To be a good trial lawyer, you've got to have a great reputation, and you've got to protect it. It's a lot easier coming in with big expectations than someone not willing to listen to you when you're walking in the door because of some past offense or some past slight. When you encounter a problem during trial, own it. Be proactive. Apologize. Move on. Run on. I jokingly say that trial work is not like the first time you were a server and the first table you ever had or the first night of the first week you ever worked, where you apologize profusely for spilling everything, not getting them everything, in the hopes of getting a big tip. Juries expect us to be good. They expect us to be advocates. They expect us to be smart. So don't repeatedly tell everyone how young and inexperienced you are. If it's that bad, it's obvious. Just move on, make your best effort, and go. Treat others kindly. To be a good advocate, you need to not only be persuasive, but you need to be personable. The jury needs to like you. If you want them to go your way, they better like you. They better trust you and believe in you. I gotta tell you, I tried a case 2 weeks ago, and I never thought I would ever see this happen in a courtroom. But one of the attorneys was trying to use the demonstrative exhibit of another attorney, and he asked to use it, and then the opposing attorney thought he was going to write on it. And the two of them actually sat in the courtroom tugging back and forth over this exhibit. I've never seen anything like it. They looked like kindergartners. And for me, it was embarrassing. Number one, I want to be able to control my courtroom, but what I thought was, why didn't they learn this in kindergarten? That's exactly what it looked like as a child yanking a truck out of another child's hand. It was ridiculous. And it's very difficult to talk about big, meaty, and important subjects that affect people's lives. And you're sitting there arguing over a full board. Make the jury or judge want to give you what you're asking for. Don't belittle the jury, the opposing party, their beliefs, or their damages. That's just dangerous. You do your job. You cut into what you can. But I always remember the old adage when people talk about it, a scar is only small when it's on someone else's face. Don't belittle or downplay something of someone else. There's plenty of ways to attack it without going after someone. Because in my experience, when you do that, when you attack people, you end up a loser. Lastly, lawyers are egocentric. They like to hear themselves talk. Please remember, it's not always about you. You take the facts and the law as you get them. You don't create that. Pay attention to the people in the courtroom. Be careful to observe what's going on. Use it to your advantage. Don't be so self-involved that you can't take advantage of what is fortuitously handed to you. Probably the most exciting thing about trial work is you never know what is going to happen in a trial. Sure, the prep work is tedious and long and maybe even boring at times. But when you get into trial, you never know what's going to happen. Now, it could be good and it could be bad, but you better be quick enough to pay attention, and if it goes your way, to be able to use it and go forward. Judge Manning used to always tell me, you never know what a witness will say, you never know what a jury will do, or who a widower will marry, and that is so true. Which comes to my last point, or close to my last point, choose your juries carefully. That is the one thing that I think lawyers neglect these days in trying cases. Number one, they don't ask or want to ask voir dire that goes to the meat and the heart of the issues in the case. Why don't you want to know what your jury's likely to do? You could have the best case in the world with all the damages in the world, or you could have liability on your side. But the simple fact is this: if you don't have the right jury, it doesn't matter what you do. You will not get the verdict you're hoping for. Lastly, trial lawyers, again, actually and regularly try cases. Nothing replaces practice. Nothing replaces experience. Now, I know they tell you all that as associates, they never allow you to go into court. I can tell you this: you need to ask. Most lawyers, unless they're in trial and billing hours, are not making money when they're in court. They would love to be able to hand off motions, summary judgment motions, any kind of discovery motions to associates that they know can competently handle them. All you have to do is ask. And I promise you, you'll be given the opportunity. So, if you want to get a job, be a trial lawyer, be an advocate. I will say that it's probably the most fun part of this job, definitely. And again, if you are interested in advocacy, which I'm guessing most of you are, that you're here, I think that's the area to go into nowadays, and particularly in our state, because we'd love to see more trial lawyers. And I think there's plenty of room for you all to come into the courthouses and try your cases. So thank you for inviting me, and I look forward to seeing the Moot court competitions. Last year, I had the pleasure of being here with Kristi Harrington and Chief Justice Costas Plakonis, former Chief Justice. And I remember our comment at the end of this was that these Moot court competitors were better than probably 99.9% of the lawyers that appear in front of us. You all work hard. We acknowledge that, and it's a great foundation for you. So I look forward to seeing you all in my courtroom over the next year and years, and I wish you all the best luck. Let's start.
Thank you, Judge Mullen, for such inspirational remarks. Now, what you're about to see is the final 4 round of our internal Moot court competition. These are the top 4 competitors who scored the highest during the preliminary rounds in the past 2 weeks. And what they'll be arguing is the case of Ellis Grayson versus the Russell County School District. Now, this problem is a fictional problem, obviously, and it was written by Kabohi Myers, who many of you know. She's a 3L student, and it was done with the supervision of Professor Bruno, our faculty advisor and the legal writing department director. And the problem was inspired by a case from Louisiana where a valedictorian student in high school was not allowed to walk during graduation because he refused to shave his beard. But in this case, A high school student has been suspended from the school indefinitely due to his non-compliance with the school's gesture policy. And the plaintiff, Ellis Grayson, a minor, brought a suit against the Russell County School District in Bismarck, Augustine, for violation of his First and 14th Amendment rights. Specifically, the two issues to be argued today are, first, does prohibiting a male student from wearing beards and earrings violate the rights of freedom of speech and expression guaranteed by the First Amendment? And second, does prohibiting male students from wearing beards and earrings violate the due process provided by the 14th Amendment? Now, we have a very esteemed panel today to judge this round, and alongside with Judge Mullen, the second panelist today who will serve on the panel is Judge Kristi Harrington. Now, Judge Kristi Harrington grew up in Charleston and currently resides in Berkeley County. She is admitted to the practice of law in the state of Oklahoma, the state of South Carolina, and the United States Supreme Court. Judge Harrington was elected to the bench on February 6, 2008, to the position of the resident circuit court judge for the 9th Judicial Circuit. She's currently serving as the chief administrative judge for the Common Pleas and General Sessions in Berkeley County. This year, she implemented the Day 4 program designed to introduce high school students to various roles in the judicial system. Additionally, Judge Harrington helped to expand the 9th Circuit Adult Drug Court Program into Berkeley County. She's also on the National Judicial College of Faculty Advisory Board and is currently working on her master's in judicial studies. She recently attended courses in Los Alamos, Boulder, Colorado, to become certified by the National Courts and Sciences Institute as a forensic resources specialist. Judge Harrington is also an active member of the South Carolina Bar Association and currently serving on the Joint Task Force, and she's also a founding member of the Pettigrew Court. Now, in addition to all her judicial duties, Judge Harrington traveled to India in 2016 as a Fulbright Scholar Specialist, where she conducted training for local judges. She is also a 200-hour certified yoga teacher, and is currently, believe it or not, currently training for a 500-hour yoga certification. Judge Harrington is also a distinguished visiting professor at the Charleston School of Law, currently teaching various criminal and civil advocacy classes. And thank you so much, Judge, for being with us today and judging this round. Now, our very last panelist is Ms. Susan Dunn. Ms. Dunn is currently the legal director of the American Civil Liberty Union, also known as the ACLU. And prior to joining the ACLU, Ms. Dunn worked in private practice in Charleston for more than 30 years. For 12 of those years, Ms. Dunn litigated a high-profile and groundbreaking constitutional case challenging the policy of mandating the testing of pregnant women at a public hospital for cocaine use and the delivery of those test results to law enforcement. Her clients ultimately won a favorable ruling at the United States Supreme Court that led to a settlement of the case. Ms. Dunn won the 1998, she is the recipient of the 1998 Jen Galloway Basil Award, presented annually by the South Carolina Women Lawyers Association to a person who has contributed to the advancement of women in the practice of law in South Carolina. Ms. Dunn received her undergraduate degree from Duke University and her JD from the University of North Carolina in Chapel Hill. Thank you very much, Ms. Dunn, for being with us today. At this point, I would like to call Lindsay Luthringer, the chair of the internal competition, to call the competitors on stage and begin the round.
All right, so our final four competitors for the competition. So today, representing Ellis Grayson, we have Arielle Larsen and Devin Hludzik. And representing the Russell County School District, we have Zachary Horwath and Victoria Hurse. Judges ready? All rise. Oyez, oyez, oyez. All persons having business before the United States Court of Appeal for the 15th Circuit are admonished to draw near and give their attention, for the court is now sitting. The 15th Circuit is now in session. Chief Judge Harrington, Judge Mullen, and Judge Dunn presiding.
Seated. Good afternoon. Is council ready?
Madam Chief Judge, may it please the court.
Yes.
My name is Devin Hludzik. I, along with my co-counsel, Arielle Larsen, are here today on behalf of Ellis Grayson, the appellant. We are requesting 2 minutes for rebuttal.
You may.
Thank you, Your Honor. We are requesting this court reverse the district's court decision of summary judgment as there are genuine issues of material fact. The standard of review is de novo. We are here to ensure justice for Ellis Grayson, an exemplary student, student athlete earning multiple full scholarships, and a member of multiple school organizations. We're requesting reversal of summary judgment for 2 reasons. First, that Mr. Grayson's First Amendment constitutional rights have been violated, as his beard and earrings are forms of expression protected by the First Amendment, and the school lacks substantial justification in limiting these. And second, in which my co-counsel will elaborate further, that Mr. Grayson's 14th Amendment constitutional rights have been violated, as he was given improper procedural and substantive due process. The United States v. O'Brien Supreme Court holds that when an expression lacks spoken or written words, an expression can still be protected by the First Amendment if it's found to be expressive in its conduct. Further, O'Brien states that when there are combined elements of speech and non-speech elements, there must be substantial justification in limiting the non-speech elements. Mr. Grayson's beard and earrings are forms of individuality and expression. He began growing a beard at age 14 and suffers from pseudofolliculitis barbae, which is a medical condition, causing him to grow severe ingrown hairs and pustules. Because of this, on the first day of his senior year, he came with the beard and earring. He was then suspended from school. Mr. Grayson's beard and earring are forms of expression as he expresses his individuality and cultural heritage. Mr. Grayson also wore an earring that was given to him as a family heirloom by his grandmother. Holsapple v. Woods holds that the decision to wear one's hair at any length or in any manner is unconstitutionally limited. Your Honors, the school allows Mr. Grayson to wear mustaches but not beards. Mr. Grayson's beard is protected in this case as it is a form of hair. The case does not specify whether it's the hair on his face or the hair on his head. Further, in Doe v. Units, there was a case where it was a transgender male to female. This student wore clothing that expressed their individuality and their sense of pride in dressing as a female. This court suspended the student and they were seeking medical treatment as they were bullied and severely harassed. This case held it was unconstitutional in order to limit these freedoms as it was expression and there was medical testimony upholding this. Your Honors, Mr. Grayson has an expert testimony stating that he does suffer from PFD. He was also bullied and harassed by his peers. Because of this, it is unconstitutional for them to limit this as he does have these medical testimonies.
How does the earring play into a medical treatment?
Your Honor, the medical treatment is more for the beard aspect, but his earring was given to him as his grandmother, and it supports his family and his cultural and family pride by
So I
wearing
think
it.
it's somewhat disingenuous for you to indicate that the earring is part of a medical diagnosis. Would you agree?
No, Your Honor. If he was bullied and harassed and he had to seek medical treatment, as far as the record goes, it does not indicate that it was for.
So you really have two separate arguments, one for medical and then one for sentimental for the earring. Is that what I'm hearing?
Yes, Your Honor, but they're both forms of individuality of
So
expression.
how is sentimental federally protected?
It is still a form of his individuality in this case, Your Honor. It's still expressing himself and his sense of pride in his family and his cultural heritage. The school also lacks substantial justification in limiting these, as there were two instances, one in 1984 and one in 1997, in which there was peer-to-peer bullying and violence ensued. Although the school did punish these students individually, they were punishing the victim as opposed to the bullies by prohibiting them from wearing the beard and earring to school.
I mean, Counselor, is that really the test? I mean, is the school district supposed to prove substantial justification?
Yes, Your Honor. The Supreme Court in O'Brien holds that in order to limit a First Amendment freedom of expression, they have to be able to substantially justify these limitations.
And is that the same standard that's reflected in Bagley?
I'm sorry, Your Honor, I'm not familiar with the Bagley case. Also, in Morse v. Frederick, there were students that brought a flag promoting drug use, and in this case, the court upheld that it was constitutional to limit them bringing these flags as they were promoting illegal and negative conduct. Mr. Grayson's beard and earring are not illegal in their conduct. Also, the Supreme Court in Tinker v. Des Moines states that in order to limit a First Amendment freedom or expression, it must substantially and materially interfere with the discipline of the school. Your Honors, when Mr. Grayson was teased and harassed by his peers in the classroom setting, he was more of a disruption than when he was growing his beard.
But the rules of the school are based on general experience. And didn't the school district say that there have been violence in connection with beards in the past? That's what they were really concerned about.
Yes, Your Honor, it was based on these two instances, but these were decades ago, and they're archaic principles. The purpose of the dress code was enacted aside from just promoting a safe learning environment, but also to promote individual growth and development of their individuals and students, as opposed to just limiting these uncomfortable, possibly moral feelings that these students have. They should be growing them to be more accepting and understanding of their peers and what they may be trying to express or show of their own family heritage. So by limiting these principles that happened decades ago, things have changed, and these students should be taught and punished as opposed to those beliefs, not just limiting them as it comes.
Do you believe school dress codes should be abolished completely?
No, Your Honor, I don't think that they should be abolished completely. I think that they are able to be regulatory, but they can't be regulatory that they infringe on rights, constitutional rights, especially those of expression, and that's what Mr. Grayson is here for today. And for these reasons, Mr. Grayson's First Amendment constitutional rights have been violated. Thank you, Your Honors. May it please the Court. Good evening, Your Honors. As my co-counsel recently introduced, my name is Arielle Larsen, and I will be discussing the 14th Amendment of the Constitution. Your Honors, Mr. Grayson's constitutional rights, guaranteeing the due process of the law, have both been denied, both procedurally as well as substantively. Mr. Grayson has not been given his proper opportunity to be heard, and he has faced arbitrary enforcement, a disparate impact, and his family privacy has been invaded. Under due process of the law, Mr. Grayson is entitled to notice and a proper opportunity to be heard. As the U.S. Supreme Court case of Goss v. Lopez from 1975 states, any student has an opportunity to be heard, and depending on that appropriate accommodation of the competing interests involved, the student must receive a hearing as practicable as possible. Unlike Goss, Mr. Grayson was not given a practical hearing. The students in Goss were given a 10-day maximum suspension. In our case, Mr. Grayson was suspended indefinitely. Your Honors, this is not practical, and his hearing was not set for 28 days until after his date of the initial suspension. This would be detrimental to his academic career, especially in that he would be risking 2 potential scholarships that he has on the line by missing too much school and being ineligible to graduate. Furthermore, at a school board hearing, Mr. Grayson was treated inappropriately. There was a school board member who placed a can of shaving cream and a razor in front of him and told him that if he went to the bathroom right then and shaved his beard and removed his earring, he would be able to return to school the next day. If you recognize here, this was an ultimatum. The school board had already made up their minds prior to even speaking to Mr. Grayson. In fact, they brought it with the intention that he would follow. They did not hear his medical testimony. They did not hear his reasonings for his hearing. And that was the issue with procedural due process of the law. Moving into substantive due process, Washington versus Davis states that all governmental intrusions into fundamental rights and liberties must be fair, reasonable, and must be done in furtherance of a governmental interest.
Let me interrupt you a minute, Counselor. This is an appeal of a summary judgment decision.
Correct.
Is your position that there are elements of material fact that are in dispute, or is your position just that there are no dispute of facts, but that legal decisions were wrong? What are you really saying?
There is a genuine issue of material fact. In fact, as far as substantive due process of the law, we have conflicting expert testimony in both cases. In our case, I would like to point out specifically that there is a disparate impact claim on Mr. Grayson. And Dr. Monica Woods, who provides in her expert testimony, is that African Americans face a 45% to 83%, which is nearly half to more than half, of a disparate impact against others. So African American males and those with coarse and curly hair have a higher chance of developing PFB and having to deal with this condition. Specifically, Washington versus Davis states that the central purpose of the Equal Protection Clause of the 14th Amendment is the prevention of official conduct that's discriminating on the basis of race. To completely ignore Mr. Grayson's medical condition in this situation would be discriminatory, especially because Mr. Grayson hasn't, while he has multiple ways that he can choose which treatment he would like, it is not up to the school board to determine specifically which medical treatment that he must pursue. In this case, Dr. Monica Woods states that 100% effective treatment is not to shave, and this is Mr. Grayson's right. Additionally, Mr. Grayson has been treated arbitrarily. There is a U.S. Supreme Court case, Scott versus the Board of Education, where here, regulations that only apply to female and male students specifically means that it is about gender taste and not about safety, order, or discipline. In this case, a female student showed up to school wearing slacks. This is more considered a male type of garment of clothing than it is a female. However, in this case, the court held that the school was improperly punishing her by placing her in detention, specifically because when a school has different regulations for girls and guys, it's about gender taste and not so much safety and order, which is similar to our case because Mr. Grayson is not able to wear an earring, and as my co-counsel has previously stated, there is no further interest of safety by preventing male students from wearing earrings because it was the behavior that caused this issue. Mr. Grayson should be entitled to wear an earring specifically because his female counterparts are able to wear an earring. And just as Scott versus the Board of Education ruled, it's not fair to prevent students from one sex versus the other from being able to wear certain articles of clothing and the other ones not. Which also leads me into my final point, that Mr. Grayson's family privacy has been intruded upon. There is a court case, Antel versus Stokes, that specifically prohibits or states that a school can prohibit the wearing of objects that conspicuously relate to an unapproved organization. In this case, memberships that are unapproved outside of the school are able to be restricted if they are offensive in nature, illegal in conduct, or that can be harmful. In our case, Mr. Grayson's earring and beard, they're not harmful, they're not offensive. His beard is due to a medical condition, and his earring is dating back to his family history. In fact, both of these are things that are not anything like that in the Antel case. And in Antel, while the school did have the ability to prohibit this conduct, wearing of a shirt or a cap or anything else that has offensive or unapproved language on it can be removed. A beard and an earring in this case.
But isn't this more like a situation where instead of saying this is inappropriate or offensive, the school district is just taking the position that we're just going to eliminate the temptation here altogether? It's more like saying you can't wear t-shirts that say anything. It says you can't wear any earrings, you can't wear any beards.
Your Honor, I see my time is up. May I answer your question, please?
Yes.
You may.
Thank you. In this case, this is more about gender inequality by preventing Mr. Grayson from not being able to wear the earring and allowing his female counterparts to, and as well as the beard, this is an issue that relates to a medical condition. By implementing these policies based off of information that's decades old, they're not accepting that society has changed and conformed and recognizing that if this was the behavior, this automatically goes back to the behavior of students and not Mr. Grayson's free expression. For the foregoing reasons, we respectfully request that summary judgment be reversed. Thank you, Your Honors.
Thank you.
May it please the court.
Yes, ma'am.
My name is Victoria Hurse, and I, alongside my co-counsel, Zachary Horwath, represent the appellee, the Russell County School District. This case is about students, their safety at all times, and providing an excellent education consisting of productive, efficient, and effective rules and regulations. There are two issues before us today. I will be discussing the First Amendment, and my co-counsel will be addressing the 14th Amendment. As to the First Amendment, the school district respectfully requests that this court affirms the trial court order granting summary judgment for two reasons. First, the wearing of a beard and an earring does not warrant protection under the First Amendment. Second, even if such conduct is found to be freedom of expression, the school district dress code policy is justified using both of the Supreme Court cases, O'Brien and Tinker. As to my first point, the wearing of a beard and an earring does not warrant protection under the First Amendment. The United States Court of Appeals for the Fifth Circuit has found that one's asserted freedom of choosing their hair length does not rise to the level of fundamental significance which will warrant such as a constitutional right. In the instant case we have before us today, Mr. Grayson's wearing of the beard and the earring does not rise to the level of fundamental significance which will warrant such as a constitutional right. On page 6 of the record, Mr. Grayson stated that he was wearing his beard for his own personal liking. This is very similar to the case Harvey Smidget, in which a junior boy came to school in violation of the dress code policy prohibiting his hair from being too long.
How does the facial hair disrupt the educational environment?
Well, Your Honor, it has been proven that the wearing of the beard is disruptive because on page 21 of the record, there was an incident in which a group of junior boys were harassing a freshman boy. They held the freshman boy down to the ground. They took a battery-powered shaving razor, and they shaved off his beard, which resulted in many cuts to his face. This incident is not only disruptive, but it shows to those that it's very violent and dangerous, including the harassment of students within the educational environment.
Is it okay for him to have a mustache then? And what's distinguishable between any facial hair?
The main thing that distinguishes the beard, the regulation in regards to the beard and the mustache is being that there have not been any incidents that go to serve proof that a mustache should be prohibited because of any violent or disruptive incidents. Again, being that this student was attacked and had his beard shaven off, these other students should have been in class or they should have been doing something more productive. But instead they took the time to harass the student merely
How is
because he was
that?
wearing the beard.
Well, how's that Mr. Grayson's fault? Shouldn't the school district be more proactive about monitoring what's going on? He hasn't had any issues in his new school, correct?
No, Your Honor. However, in the school district that we're discussing today, the school district was very proactive versus reactive, and the
Well,
policy
if it's
is
disruptive in one place environment, shouldn't it be as disruptive in another school environment?
Well, Your Honor, in regards to the school district before us today, it is important that it attacks the problem and protect the students, especially within that school that has gone to show purpose that is very disruptive.
Is that the only incident involving bullying or a student being beaten up? Was Mr. Grayson with the facial hair?
No, Your Honor, actually there was another incident that occurred on page 24 of the record in which a male student was attacked for wearing his earring. He was actually taken into the bathroom and he was cornered by 3 other students that snatched the earring out of his earlobe, which resulted in it being torn. And once it was torn, he had to be rushed to the ER to have it sewn back together. And again, the school district was more proactive than reactive in the situation, and that led to the implementation of the...
Counselor, is there any reason why that girls aren't exposed to exactly the same danger?
Well, yes, Your Honor, being that there have not been any violent or harassment incidents in regards to females in the school district. It was only a young man that was wearing the earring in which he was harassed for coming to school and wearing the earring. So
But isn't this sort of blaming the victim when the real bad actors were the people who beat him up? Isn't the school more concerned about that than the earring?
No, Your Honor, the policy was not implemented at all to punish anyone, more so to protect the students and protect the ones that were victims and protect any other of the future students from becoming victims. In fact,
females are still allowed to wear earrings, correct?
Yes, Your
And
Honor.
have long hair.
Yes, Your Honor. And again, being that there were no incidents that go to serve proof that if females were to wear their hair long or wear earrings, that there would be anything disruptive or violent. But being that those incidents did involve the male students, the school district is here to implement that and protect the safety of the students. And of course, we're here today in order to ensure that
So
Mr.
if
Grayson...
a female student got into an altercation and her hair was pulled, are you going to make all the female students shave their hair?
No, Your Honor, the school district but the school district would actually have the discretion to decide as to what they would do in that situation. But if a student was to have her hair pulled, and it resulted in the fact that it was being long, then the school district has the discretion to decide as they need to in order to truly protect the student. But that would be very different from what we have today, being that the two incidents that occurred were very dangerous and very violent and resulted in the students needing medical treatment.
Ms. Hurse, why is this PDF that Mr. Grayson suffers from, why isn't that a safety, health, and welfare concern for the school? Why are you concerned about that?
Well, Your Honor, the exception should not be made for Mr. Grayson based on his medical diagnosis for two reasons. First being that Mr. Grayson was able to comply with his dress code policy 3 years prior to. And also there are many other treatments that Mr. Grayson can take, such as laser removal, washes, and RESNA. However, in the record, Mr. Grayson does not state that he has attempted to even take into account any of these alternatives or even try these alternatives before he chose not to comply with the dress code policy. And under O'Brien, the school district dress code policy is justified because it furthers the important governmental interest of ensuring the safety of the students. And ultimately, ensuring that all of the students are safe provides a very productive and efficient educational environment. And under Tinker, the standard is to determine the constitutionality of the school authority's actions. It must determine if it materially and substantially interferes with the requirement of appropriate discipline and operation of the school. Again, being that we had the two violent incidents, it goes to serve proof that these incidents are disruptive and therefore they should be regulated.
So is the school district's position that it didn't matter if it was a medical condition, the safety of the school preempted that, and that the rule is the rule and there are no exceptions?
Well, no, Your Honor, it wouldn't be all in all, no exceptions, but particularly to the case we have today and within the scope of what we're discussing today with Mr. Grayson, being that he was in compliance for a long period of time before and that there are other alternatives that he has not even taken the opportunity to try, Mr. Grayson should therefore be in compliance. And under back to the Tinker standard and then materially and substantially interrupting the school environment, Mr. Grayson must be in compliance to no longer attract the attention of other students or divide the students who do not have beard and do not have earrings. And in this particular case, the school district strives to ensure that there are no hostility between the students and that everyone is treated the same, and ultimately ensuring that the academic atmosphere is well and that the students have a good quality education. And for the foregoing reasons, the school district respectfully requests that this court affirms the trial court order granting summary judgment on Mr. Grayson's First Amendment claims. Thank you.
May it please the court?
Yes, sir.
My name is Zach Horwath, and as my co-counsel previously stated, I will be addressing the 14th Amendment claims, respectfully requesting this court affirm the lower court's decision in granting summary judgment for two reasons. First, the school district did not deny Mr. Grayson procedural due process because he was afforded notice and a fair opportunity to be heard. And second, the school district did not deny Mr. Grayson's substantive due process because the school policy does not disproportionately impact him, nor is it arbitrarily applied. Beginning with procedural due process, the Supreme Court held in Goss v. Lopez that a school is required to provide a student with notice and a meaningful opportunity to be heard. Now, Mr. Grayson was afforded multiple meaningful opportunities to be heard, as well as notice immediately upon entering school that day. On page 23 of the record, it states that he was taken from homeroom, immediately sent to Principal John Prather's office, where he was informed of his violation, as well as the consequences associated with it. His mother was then subsequently informed, and the two of them were ultimately given a separate meeting with the principal, superintendent, and ultimately at the end of that, a full school board hearing. This is multiple opportunities that Mr. Grayson was informed that he was in violation, gave him an opportunity to comply, and then he was able to plead his case, at which point the school board voted unanimously against allowing this exception.
Sir, let me ask you, how do you justify a school board member pulling out a razor and a can of shaving cream and said, go to the bathroom, and if you shave us off, you'll be admitted back to school in the morning? What's
Yes.
that procedural due process? anyone any kind of confidence in the school board or procedural due process that's afforded to them when you've already got one board member who is obviously predetermined what their stance is before hearing anything.
Yes, Your Honor. And the school board does not condone the unprofessional behavior of that school board member. However, if you apply the standard set out in the Leonard v. School Commissioner of Attleboro case, in which a similar isolated incident occurred, where the school board member there asked that the violating student cut his hair so that he could go back to school, very similar to our case, and the court held there that isolated incident did not affect the fairness of the hearing. And further to that point, in that case, that was a 5-4 vote, which is, in that case, is a clear indication that bias could have had a much stronger impact on that vote, where in our case, it was a unanimous vote. That shows that the school board members were not biased. They very passionately believe in the dress code and that the safety of the students is more important than allowing this exception. Moving on to substantive due process, the substantive due process were not violated. First, because the dress code policy does not have a disproportionate impact on Mr. Grayson. As opposing counsel brought up Washington v. Davis, which is a Supreme Court case, it states that the disparate impact numbers, although it may affect a student or a person with more disproportionately than others, that must be coupled with a discriminatory purpose. In that case, applicants to the D.C. Police Department were complaining that the application and testing were disproportionately impacting them in that more black applicants were failing than white applicants. However, the court held that although these numbers might have a disproportionate result, there is no discriminatory purpose. The test is in place because it's necessary to determine who qualifies as an adequate police officer. In this case, the purpose is safety. It's obvious that it's safety. It's not in place for...
How is it obvious that it's safety? How does a beard make you less safe than a person who doesn't have a beard?
Thank you, Your Honor. It shows that it is for safety because it was a direct response. It was applied immediately following two violent acts. It wasn't arbitrarily implemented at any time.
It may not have been arbitrary, but it may not have been stupidly applied. I mean, the beard did not cause the danger in those situations. Uncontrolled young men who attacked another student did. How does the beard really affect safety?
Well, Your Honor, in that instance, the students specifically targeted that student for a beard, beginning by verbally harassing him.
So if they'd arrest him because he was fat, you're going to punish the fatness? It just doesn't make sense.
Well, Your Honor, if in that case, it was the beard that caused the violence to occur, and the school, it would be negligent if it did nothing.
Were there any other students with beards?
No, Your Honor. Otherwise, they would be in violation of the dress code as well.
They would have been beaten up as well, would be your argument.
Well, Your Honor, the school wouldn't like to take the chance of having to react to any opportunity for students to be beaten up for non-compliance with the dress code. And moving into arbitrary enforcement, the policy was not arbitrarily enforced because its enforcement is necessary to maintain safety, as established in the Stevenson Hurse Board of Education. If evidence exists that establishes that a regulation is founded on a rational basis, then the policy issue is not arbitrarily applied. The rational basis...
What is the rational distinction between an earring in a girl's ear and an earring in a boy's ear?
Well, Your Honor, the girl getting her earring caught in a locker is an accident, an unfortunate accident, but an accident nonetheless, whereas the beard and the earring on the male was the sole cause of the violence. These are acts of violence, not an accident. And the school is proactive in preventing acts of violence, but it cannot be proactive in making these schools accident-proof. That would be less rational than trying to protect students from violent attacks that have already happened. And for these reasons, Your Honors, the Russell County School District respectfully asks this court to affirm the lower court's decision decision in granting summary judgment on both the First and 14th Amendments. Thank you.
Thank you. May you please support? Your Honors, my co-counsel and I would like to present two issues for rebuttal. First, my opposing counsels have used the O'Brien standard. The second element of the O'Brien test is that it must further a substantial limitation. Your Honors, on page 13 of the record, Mr. Grayson speaks of an incident in which a female got a earring stuck on a locker. If the safety of the students is their main concern, are they going to remove all of the lockers? Their reasoning for implementing this dress code based on these two archaic instances is the same thing as the substantial justification of trying to limit
Mr. Horwath said that the reason was that was an accident, and the other was the result of violence caused by the victim himself.
Your Honors, if this is an accident versus probable issue, either way, the safety of the students is their primary concern, and somebody was harmed. So whether it was the acts of another student or it was the acts of an accidental getting stuck on a locker, it's the same substantial justification. The second issue for rebuttal is that in Leonard, it holds that the opportunity to present oneself before an impartial tribunal is a minimum requirement. Your Honors, when the school board member brought the can of shaving cream and razor, they were prepared to tell Mr. Grayson that he had an ultimatum of whether or not he should shave his beard to be let back into school. Further, in this case, the facts of this case, the school board member told that student that why didn't he try to wear colored wigs in order to cover his hair. Your Honor, this court found that that was more of a suggestion, whereas in our case, it was an ultimatum. He was prepared to do this. So for these reasons, there are genuine issues of material fact, and we request that you reverse summary judgment. Thank you, Your Honor.
Thank you.
At this time, we're going to let the judges deliberate, and we'll come back and announce the winner. So just sit tight for a second.
The court is now back in session. We have a divided bench. We were unable to come to a unanimous decision, and without the benefit of our law clerks to do extra research, and with the understanding that in just a few moments, what stands between our ruling and a beer, right? So we decided that we would go ahead and come out with a divided bench, mainly because it was a really tough decision. But in a decision 2-1, the decision is for the school board. Again, I just want to remind all four of you, I think most of you have probably, if you've taken my class or heard me speak before, even up until my first year in law school, I used to drop classes if I had oral presentations. And the fact that you were up here in front of this big podium with two real judges and somebody who knows more law than Judge Mullen and I combined is a true testimony to your advocacy skills. So hats off to you. There's no winners or losers tonight. All four of you are fantastic. Judge Mullen, would you like to start with some critique?
Sure, and I think I just want to add to, I don't know where I missed this in law school, but I'll never forget the first time I was in the Charleston courthouse, argued a case, had lost it, walked out, and I think it was the first time it ever occurred to me, someone had to win and someone had to lose, and that's just the way it is. And I know we can all think that we know what we're doing, but again, that's just the way it is. And I will tell you, it was a very tough decision. You all are excellent. And much like former Chief Justice McKenna said last year, you all are so much farther ahead than most of the trial attorneys that we actually see. And it makes me have great confidence, certainly, in the bar here in our state, because I can tell you from our perspective, Kristi and I, it's so much fun to sit on the bench and watch good lawyers. And good lawyers for their clients. And I can tell you that it's a little few and far between, unfortunately, these days. It's just like I was speaking before about, there are very few trial lawyers who actually are true advocates and know what they're doing and have the poise, the knowledge, the ability to argue. So if we want to go ahead and jump in, and I'll start just with a little bit of the critiques. Mr. Horwath, you responded very well to questions, and that is my pet peeve, is that lawyers cannot answer my question. They tend to just keep going about what they want to talk about, and really it doesn't matter what they're talking about, because that's the only thing I'm stuck on, right or wrong. It's all I'm considering at that point. So I think you wonderfully answered your questions. You could have maybe backed down even a little bit on some things and said, I'll acknowledge this, however, because of this, it doesn't matter. And I think a lot of honesty and a little humility will go a long way, certainly in arguments. I think some of the best lawyers that I've seen in the appellate courts are ones that say, listen, I'm going to go ahead and concede this portion right now because I know this is not my strongest argument, this is, and so I'm going to go forward on this. I think that's smart, and I think you were very good at that. And I thought you were great at deflecting questions and not being thrown off, and then being able to naturally tie it back in. I'm not even quite sure at some points when you stopped answering the question and when you started in on something else. It all flowed so well that I thought it was very helpful. So y'all want to jump in? And
if I can follow up on that point, I'm asking a question as a judge because I want to know the answer. What you think is important at that point is not important. You've got to answer our questions because it is our question, and it may be something that does not really pertain, or you think but that question needs to be answered for us because it's always going to be, what was the answer to that question? And if I have to go look for that question, I may not get the answer you want me to have. So make sure you're answering the question.
And, I think this is going to sound kind of flaky because it doesn't have anything to do with the substance. But I found one of the most compelling things about your argument was your pace. That you didn't go too fast or too slow. You kept it moving, but you spoke slowly enough that you could actually be heard, which is sometimes a problem with lawyers.
That if you're in my courtroom and I can tell my court reporter is having a hard time, I'm going to interrupt you. And if I interrupt you, then that just breaks your pace. There's
you had been in my courtroom, Ms. Hludzik, I would have told you to slow down. You speak incredibly fast, and it just makes it very difficult. You had wonderful things to say, but it just makes it so much harder for us to listen to them. And then what it does is it kind of increases the pace, and then your judges become fast question askers as well. Slow down. Slow down. I understand you're in a time situation, but you want us to hear what you're saying. And so that's the two of you were very different in your pacing, and it does make a difference.
Well, I'll tell you, we said this in Hurse about you. You were unflappable. It didn't matter what we said, what we did, you were going. And you were not going to be ruffled. And there's a lot to say for someone having confidence in what they're doing and saying. I truly believe it wasn't just a position or a sign that you were assigned, which I know you were, but it was a belief. And so, and rightly or wrongly, whatever it was, I believed it, and I followed that. And there's a lot of credence to that. And you were dissuaded. You got a lot of questions. You got a lot thrown at you. You were very strong. And you did a good job. Very good job.
And likewise, Ms. Larsen, we were peppering I think all of us asked you questions, and I like the way you made sure to ask if you can have additional time, because you need to follow the protocol of the courtroom. And you knew that the time had run out, but you wanted to answer the question, so you handled that beautifully. And so you've got to be, there's so much going on when you're in trial. You've got to be paying attention to your witness. You've got to listen to your witness. You've got to observe the court, the jury, make sure the court reporter. So you were able to handle all of those things, and so that was a really good skill. Back on being inflammable, Mr. Horwath, my one criticism for you is to get a little more passion. You were pretty monotone, and we did like it, everybody's complimented, but I needed just a little more excitement from you about the school board, all right?
I will lastly go ahead and just throw this out there. You know, obviously, you have the briefs ahead of time. You obviously will have written the briefs, or at least have someone in your firm write the briefs and know what you're doing. There's no excuse to ever not know a case that a judge may ask you about. That's just something that you better know exactly everything there has to do. Again, just saying, you know, I'm not familiar. Again, you need to be familiar with that, and that is a problem. So you need to be the authoritative person on this issue, and you better have heard all the cases. So I think that's important, certainly for me.
And I thought all of you were well organized. All of you had an idea of where you wanted it to go. And any one of y'all would have been welcome in any courtroom in the state. So I really want to say that loudly. You know, I have particular interests and particular beefs. And women's voices in the courtroom, sometimes you really have to work on. You have to work on being able to slow down enough, because that's not what we normally do. But also be passionate enough. You don't want to kind of turn into one of them. You know, we want to still stay interesting and keep our personalities, but that's hard to do. And it's worth practicing. It's worth being able to be yourself and still make your arguments. There's nothing disrespectful about you know, having some personality, but I think sometimes we don't have enough models, you know, to know how it is we're going to do that. So really, if you try more storytelling rather than arguing, sometimes we can do that better, and oftentimes we can pull that off better than the guys can, really. So I just encourage you to do that. And I also want to say, you know, the plaintiff's case was so much harder, you know, in a lot of ways, and you did a good job of not backing away from it. The one thing substantively I would say is that I think one of the things that didn't come out was really the cost to the student. You know, the loss, the actually being out of school that long in his senior year. I think you could have put a little bit more of the personality. It's not just somebody who wanted to be an earring. It was a student who was trying to finish his degree, and to be put in a position where you have to make these choices when it really didn't make any difference to the school board. You know, I think just giving it a little bit more personal face when you've got a hard case. When you've got a hard case, you know, sometimes you have to make your facts as opposed to the loss and the cases that have already been decided. You want your facts to be compelling.
But you were in the really difficult position of going first, and so you were greatly improved on your rebuttal, and you were much more comfortable. I don't know if you were just more comfortable or more practiced with that one, but it was noticeably different. Your pace was a little slower, so nice work. And again, I think just as Dakota said it last year, you referenced Judge Mullen in your speech. Y'all are again ahead of the game. I think Judge Mullen and I would both be honored to have you in our courtroom. We would not be calling you down. You were prepared. You had read the material. You had the case citations. You could point me in the transcript where to go to look. Be mindful of that, though. If you're pointing me to look at something, that means I'm not also listening to you. So just be aware of what sometimes one or the other. Some judges can't multitask. So just be mindful about that.
Do you have any questions for us? Anything that? No? Because normally we never allow you to ask questions. So I just thought it would be nice to give you an opportunity. Thank you all.
So as we just heard who the winners are, I still have 5 awards to give. So with that being said, the runners-up in this competition are Devin Hludzik and Arielle Larsen. And with that being said, the champions are Zach Horwath and Victoria Hurse. We now have the overall Best Advocate Award. This award is given to the one student who scored the highest throughout the whole competition of the 3 days. And that award goes to Arielle Larsen. Last year we started the Best Brief Award. That award was designed by the previous Moot Court members, and what they did is all the 2L students submitted their 1L brief. However, this year we decided to add an addition to that, and we added the runner-up Best Brief. And clearly it was such a hit because this year we actually have a tie between the 2 runner-ups. So the 2 runner-ups for Best Brief are Jeffrey DeMonico and Brittany Point. Yes, you do have to share a flag for today. And with that being said, our Best Brief this year goes to Lauren Carroll. Thank you all for being here, and thank you all for our 2L competitors that came out and tried this year. Enjoy the rest of your night.